Thank you very much for joining us on the Voice of Job Seekers. Once again, this is Mark. If you want to know more about the Voice of Job Seekers, you can go to voiceofjobseekers.com. You can always leave us a message. You can email us, and that information is there on the site. Today, I'm really excited to introduce Tom Spiggle. Let me tell you a little bit about him. He is an attorney. He's a former prosecutor. He's author of the book, You're Pregnant, You're Fired. And he specializes specifically in discrimination. He's been quoted in Huffington Post, Washington Post, and many other law and mainstream publications. Welcome to the show, Tom Spiggle. How are you, Tom?
I'm fine. I'm happy to be here.
Well, I am happy to have you and really excited that you accepted my invitation. We've been following each other on Twitter and following each other's posts, so I'm definitely excited about how this is going to turn out already. So one of the things I definitely want to talk about these days is disability rights as it pertains to learning disabilities, and it's kind of a tricky subject because there's a lot of different facets. But just to kind of start off the discussion, how much should a job seeker who's disabled, who really wants to work, should reveal up front in their job search as they're interviewing, as they're networking, and how important it is to reveal certain types of information?
Yeah, it's a tricky question, and I think by law you are not required to reveal that information. It's just it's similar with pregnancy that you're not, if you're interviewing for a job and you're 3 months pregnant, you don't want to tell them. You're not obligated by law to, and they are prevented from asking you about it. That said, it's always we got to be practical too. And if you are trying to get a job, and once you get the job, you're presumably going to want your boss and your coworkers to like you, then that weighs in favor of disclosing more. So I think it is a bit of a personal preference, but you're not required to by law. So my own opinion is it's better to disclose less rather than more, unless you know it's going to be a significant issue for you in the workplace, and you want, pregnancy is one thing. It's obviously going to be a temporary, at least the pregnancy itself is going to be a temporary position. But, a disability can be lifelong. Mm-hmm. So if you know that's going to be an issue for you on the job, you may want to disclose it early on. That said, you're not required to legally. So I think a job seeker should not feel that he or she is obligated to share that information. It's only if he or she wants to, because they have a personal preference or because they want to make sure that the workplace that they may be joining is one that will respect their capabilities.
Right. Now, there are other disabilities that are, pregnancy is something you can see. There are many other disabilities that you can see. But how about the ones that are not visible, like Asperger's or ADHD?
Sure.
That's probably a little bit trickier, isn't it?
That's right. You're right, because obviously, and I guess with pregnancy too, it depends on what stage of the pregnancy, whether you can see it or not.
True.
But you're right. With ones, where it is a kind of disability that you cannot see, then obviously it's up to the applicant as to whether or not the job seeker, whether or not he or she wants to share that at all. She's not required to. He's not required to. And I think it's the same with a physical disability. It depends on how much you want to disclose to a potential job. If you know it's going to be an issue for you and the job, then maybe you want to disclose that early on, to know whether you're going to be accepted in that workplace. Because let's be frank, it's one thing for the ADA to be protected by the ADA in the workplace. It's another to be at a place that's only, accommodating you because they think they might get sued and not because they really want you on their team. Sure. So I think a job seeker has to, the law is that information does not have to be disclosed. Mm-hmm. But it is a matter of, we all live in the real world, and as a matter of being in the real world, I think a job seeker has to use common sense as to whether or not that information has to be disclosed. It could be, for example, if you have ADHD and it's not going to be an issue you don't think it's going to impact you on the job at all, then I don't think there's any need to share it.
Right. Well, and there are those that have learning disabilities that may be a little bit more advanced, that perhaps they've gone through and done like a master's program, but yet
Sure.
when it comes down to handling certain types of pressures and certain types of time restrictions on the jobs, it may debilitate them to a certain degree.
Sure.
So, I understand what you're saying. You kind of want to diffuse the bomb before it goes off, so to
Yes.
speak. But at the
Yeah.
same time, you don't even know yourself how it will manifest itself
Yes.
when it comes down to certain tasks and abilities that you'll need to perform on the job.
Yeah, and that's an excellent point. I think that somebody who's looking for a job, to the extent that you can, you need to find as much about that job as possible, so you know if it's going to affect your disability, or whether or not it's going to the job is going to impact it at all. And that is one thing that you can. I mean, it's certainly acceptable in an interview. It's acceptable
Mm-hmm.
both for the job applicant and for the employer, potential employer, to talk about the specifics of the job. For instance, let's say if you have a bad back,
Mm-hmm.
and it would be covered under the ADA, and you know that you can't lift more than 50 pounds. You can ask in the job interview, or try to find out, as part of this job, am I going to have to lift things that are over 50 pounds? The same is true for the employer. Potential employer can't ask you, well, do you have a bad back? But
Mm-hmm.
the employer can say, one of the requirements of this job is you be able to lift, packages that are heavier than 50 pounds. Because that's another thing. Just because someone has a disability and is protected by the Americans with Disabilities Act, they still have to be able to perform the essential functions of the job.
Mm-hmm.
So, as much as possible, a job seeker needs to find that out. What are the essential functions of the job? And if it's obviously a bad back is one thing. I mean, if you
Right.
know you can't lift 50 pounds, that's easy enough to ask. If you have, a mental disability that might make certain tasks more difficult for you, might, for example, make working under pressure more difficult for you, then you need to find out if part of the job means working under pressure. Again, sort of a facetious example, but if you're going to be an air traffic controller, if you're applying for that job, you got to be able to handle some serious stress. And if you know that's an issue for you, you need to find that out in the job interview, or by the job descriptions. And from the employer's perspective, those kinds of questions are fine to ask. For an employer can't inquire, can't ask a job applicant, do you have a mental disability? But they can say, they can talk about the requirements of the job. This job requires, great attention to detail. It requires, working under high pressure. And then the job applicant has to decide whether those things that he or she can do on the job.
Right. Yeah. So it's a matter of the job seeker doing enough research and detailed research and understanding his or her own limits and being able to ask questions that will ascertain that information.
Right.
Yeah.
Exactly.
Yeah. Now, do employers have to entertain the same considerations for learning disabilities than they do physical ones?
Yes, they do. It doesn't matter under the main statute that protects these are the Americans with Disabilities Act, and that applies to mental disabilities just like it does physical ones.
Mm-hmm.
And the act was broadened substantially in 2010 by Congress, so now it covers almost any condition, certainly a permanent condition that affects what's called a major bodily function. That can include, functioning of the nervous system, functioning of the brain.
Mm-hmm.
So absolutely, if you've got ADHD, if you've got some other kind of mental disability, you're still covered by the Americans with Disabilities Act. One point to remember, though, for job applicants is the Americans with Disabilities Act only applies to employers that have 15 or more employees.
Mm-hmm.
So if you are applying to an employer that has 14 employees, you are not, the ADA does not protect you. It's a little bit arbitrary, but that's the way the law works. Now, there can be state laws. For example, if you're in we're right outside the District of Columbia. If you're in D.C., there is a D.C. Human Rights Act, which covers all employers, and it acts much like the ADA. In Virginia, where this office is located, there isn't a substantially similar state law, so it's only federal law. So that's one thing to consider, is how big the employer is as to what rights you might have.
So really, there's a lot to consider ultimately when not just understanding what the job requires and what the job regulates, but also the state laws and where it protects you and where it doesn't.
Yes, yeah, and I think for listeners, certainly, you can go to Google and research these issues. Another good
Sure.
way to do it is most states have some kind of Office of Human Rights. Some of them have them even at the county level, but you can usually call those offices, or maybe go to their websites, but certainly call those offices. And a lot of times they will be able to tell you, what state laws apply, and whether there are different laws in your state. And sometimes even counties, even their county ordinances that might provide you more protection.
Sure.
So that's a good way to find out, is to call those offices.
No, that's great information. And I think, I think a lot of people are jumping the shark, so to speak, when they go from not having education and used to working jobs where there's a lot of manual labor, it's not as project intensive, to where they're going to a job where now it's required for them to use more critical thinking and having to develop a certain type of business acumen that they never had before. So they're changing the way they're learning because of school, and they have to change the way. But all of that said and done, they have to kind of examine the laws that are surrounding them as well. Especially, they're going to consider a job search, where at first there's a lot of learning, and if you have a learning disability, of course, that could impede your chances to continue on in the job, especially after 90 days.
Yes, yeah, absolutely.
So great. So the other thing I want to ask too is, while I'm thinking about it, is people who have these disabilities, do they have to prove the severity of the disability at any point?
Generally, no. It doesn't matter how severe it is. The only reason I hesitate at all, under the Americans with Disabilities Act prior to 2010, courts were very restrictive as to the definition of what constituted a disability. And one of the areas that they used to limit how the law applied was temporary conditions. So, for instance, if you had, let's say, episodic depression, so it might affect you for a month or two out of the year. But that was it. Some courts would say that, because it was episodic, that's not a disability. That generally does not, under the new ADA, the one post 2010, which applies today. Those kind of temporal restrictions normally don't apply. That said, there are still, if you had a condition that was temporary and going to last less than 6 months, a broken bone, let's say, you may not be covered by the ADA. But if it's a long-term condition that you have of any kind, it doesn't matter. It doesn't matter how severe it is.
Right. Okay. Yeah, I think when people have been, even have crossed a line from having received disability for a while, and of course, in essence, it's not the employer's concern how long they were on disability previous to being employed or being interviewed, but it may matter if it's going to, again, affect the way that person works and that way that person functions.
Yeah, that's a good point. I mean, the severity of the condition could affect what accommodations would be reasonable for the employer to provide you. If you have a very severe condition that it may require different kinds of accommodations than if you have one that is, not as disabling. Another thing to consider for your listeners that may be disabled, state level disability laws, like Social Security disability, and certainly disability insurance that comes through a job or a former job. Those are very different in terms of how they define disability, in terms of how they operate. Those are different from the Americans with Disabilities Act. So I think for listeners that are it's a complicated area of the law. And I think if folks have questions about it, it's not a bad idea, to schedule some time with an attorney to find out how the law might affect you, because you're somebody who's on Social Security disability who's coming back into the workforce. The same rules that affected their Social Security disability are not going to be the same under the ADA. So it never hurts. Again, you don't have to hire an attorney, but just take an hour, go have a consultation, and figure out how the law applies to you going back into the workforce.
Yeah, I've understood in the past that for some of these are so complicated that it can take a while to sort out if it should ever escalate beyond whether to determine that there's discrimination involved, whether the employer is making a decision or not deciding to hire someone based on discrimination and their handicap or the disability.
Yeah, and it's enormously complicated, and you can't even count on your employer's human resources officer or department, if they have one, to know that area of the law. And so it is complicated. For an employee, they really need an advocate for themselves, even if it looks like the employer is trying to do the right thing. It may just be that they don't know the law that well. Mm-hmm. So it can be very complicated. It can be a lot of like shades of gray as to whether or not there's been discrimination or not. It is just it's a tough spot for a lot of people.
Yeah, I used to work for the American Bar Association once upon a time.
Okay,
and as a manager, it was interesting when we brought up, even when somebody had like a slight back condition or shoulder back condition, how carefully they treaded, and pretty much they treaded on the side of caution and being accommodating.
Right.
Because it was, they bought even somebody who was a physical therapist, and they had somebody who was an ergonomic specialist to kind of look at those things. They treated very carefully. So I don't know if it's been some years now since I've worked with them, but I imagine a lot of workplaces are kind of siding on on the side of caution when they're approached, or when they're subjected to even somebody having a sudden disability like a car accident or something similar.
Yeah, no, it's a great point. I think there are a lot of employers who want to do the right thing, and they will be proactive. So I think for that reason, if you have a disability that is affecting you at work, let the employer know and ask for some help, because in a lot of instances they will try to do the right thing, and they will err on the side, as you say, of providing the accommodation. But that's another important point for your listeners. An employer has to know you're disabled before they can comply with the Americans with Disabilities Act. And as you mentioned, for disabilities that are not immediately visible, particularly mental disabilities, an employer may not know that you have ADHD, may not know that you have narcolepsy, may not know that you have something that is affecting your work. And if you don't tell them, if you don't put them on notice, then if they take action against you, it might not be in violation of the ADA because they didn't know. So I've talked to a lot of folks who are scared to tell their employers, and I understand that. But the truth is if they don't know, you can get fired for something that, had they known that you had a disability, they could not fire you for.
Right. So if somebody's going to put an employer on notice, or even let's say that they've been working there for a while, and I didn't mean to delve this deep into it, but while we're on it, somebody's been working with an employer for a while, and they do, for whatever reason, they have a sudden, where they need some accommodations. What is the best way to kind of put them on notice so that there's some kind of track and some kind of trace on their requests?
No, it's a good question. An email is fine. Anything that's in writing with a date stamp, an email to your whatever the proper chain of command is. Certainly, if there's a human resources office to human resources. If not, then to your direct boss. But yeah, it's always better if it's in writing. So if you've got email, which most people do these days, that's the best way to communicate it.
Okay.
You can do it orally too. I mean, you can go in and tell them certainly, but it's always best, even if you do that, to follow up with an email.
Sure.
Like you say, in case there is later some dispute about what you said, it's always better to have something you can point to in writing.
Yeah, I think you should always keep anything along those lines where you're asking, somebody to go out of their way to keep documentation close by. Well, that
Yep.
was a great part of the discussion. Part two, as we discuss here, something a little bit more rarely discussed is talking about the racial pay gap and the gender pay gap. And I kind of lump those two together because if you're a woman of color, you kind of face a double whammy, so to speak. You face the fact that you're of a different ethnicity, as well as that you're a woman. So, although we're familiar with the gender pay gap discussion at large in legislation, do you think the racial pay gap will be treated the same as with the gender pay gap?
It certainly hasn't to date, right? I mean,
Right.
I think it's a good discussion point because you don't hear much about it, whereas you do hear quite a bit about the pay gap between men and women. And partly that could be because there is in terms of the legal side of it, there is the Equal Pay Act, but that does not apply on the basis of race. So it only applies on the basis of sex. So if you've got a woman of color who is being paid less than her counterparts, she would have a claim under the Equal Pay Act because of her sex, but she would not have it because of her race. And for for instance, a black man who's getting paid less, he would not have a claim under the Equal Pay Act. That doesn't mean he wouldn't have a claim. He could have one under Title VII, which is the big anti-discrimination federal law, Title VII of the Civil Rights Act of 1964.
Right.
There would be a claim under that, but there's not a specific law that applies to pay differential on the basis of race. So I think it's an excellent discussion point because it really, we know the pay disparity exists, but there has not been the groundswell of attention that there has been for the the Equal Pay Act and for pay differentials based on sex.
Well, it's interesting because in essence, if somebody was to go and file an EEOC based on the fact that there's a lack of fairness,
Yes.
That would be the only way right now, as it stands, that somebody can have something plausible to file if there is something that is that's in question.
Yeah. No, and the tough spot for for example, a black male there's a pay disparity. He has to show that that the pay differential was the result of a discriminatory intent, as you say, for filing with the EEOC. A woman who's able to file under the Equal Pay Act for the same pay disparity does not have to show that it was discrimination. All she has to show is that the pay disparity exists, and that the pay disparity is between men and women. She doesn't have to show that the employer intentionally was intentionally discriminating.
Mm-hmm.
That's not true under Title VII, which is what a man of color would have to use. So it's not that he wouldn't have a claim, but it's much more difficult one to make than under the Equal Pay Act.
Right. Well, I'm thinking as well that that it's difficult. I think, and I have no other than being exposed to the ABA and its quirks. Intent is generally very difficult to navigate and try to prove.
That is true. It is a more difficult standard. It's not impossible, though. I mean, you don't have to have direct evidence. The evidence can be circumstantial. If you're a black male in an organization and every other white male in the organization is paid more than you, Well, that's circumstantial evidence of of discriminatory intent, even though you don't have an email or somebody saying something to that effect. But your point is well taken. It's for Title VII cases, for discrimination cases, you have to get, unless you have direct evidence, you've got to get in somebody's head, and that can be difficult to do. Not impossible, but it can be difficult.
But the common thread probably would help to have people who are willing to say that, yes, I have been in on discussions where the disparities were the intent of the disparities in pay, do exist because these comments were made. In other words, having some allies would really help.
Oh yeah, no question. That is preferable. That is preferable. You don't have to have it. Again, the circumstantial evidence of if you're the only black man in an organization, or the only black men in an organization. Let's say they're more than one are paid less than their white counterparts. That is evidence of discrimination. But you're absolutely right. I mean, if I'm going to take that case to court, I'd much rather have that evidence plus as you say, somebody who was in the board meeting, somebody who overheard the boss saying something that was racist. That would certainly help that claim quite a bit.
Right. So I guess part of it is, and I guess for me, I remember growing up with my aunt and as a teen, and she was a black woman on the west side of Tampa. And also, black and being a woman, and worked for an entity where, she was one of the few black nurses that were there. I just feel the reason why I think I get a little emotional about it, and when I hear about some of the challenges is back at that time, especially, she was paid much lower than a lot of her white counterparts for being on those side of the tracks. I guess all that to say that there is the possibility as well that there are those who have are in places where that are smaller, where you kind of have to know the market value of where everybody else is in order for you to kind of make a case to say that there's a disparity that is taking place.
Yeah, no, that certainly helps. And while the Equal Pay Act statute is a very powerful statute, it's there are a number of defenses that employers can use. So just the mere fact that a woman is paid less than a man does not necessarily mean that the Equal Pay Act has been violated. For instance, employers are entitled to, pay somebody more because of experience, or because of market factors, as you suggest. Mm-hmm. So, yeah, it would be helpful to know what the market rate is, and if you're being paid below it, it's going to be harder for that employer to defend the pay disparity. But there's no question that as to to your mother and the abuse is widespread. Mm-hmm. Things have gotten somewhat better, but not markedly so, and particularly for women, as you say, that are in smaller markets that may not have attorneys that do this kind of work, that may not be even aware of the law. There are egregious violations that go unremedied every day.
Well, I appreciate you using the word abuse. I know that when I've talked with other colleagues, they don't see it as abuse at all, or long withstanding abuse and discrimination. They say, well, job seekers should do their homework and do it. It says it's a lot deeper than that. Why should they have been subject to that kind of disparity from the beginning, and that's kind of where people are in their mindset, and I think that that's going to be part of it. But is there possible legal actions forthcoming regarding legislation, since you're in DC, if that the racial pay gap could have the same and be treated like the gender pay gap down the line? Is there a possibility that could take place?
Not. I wish I had a better answer, but I am not aware of any efforts to do that. And any sadly, as you know, anybody that watched the debate last night or paid attention, that the chances that Congress is going to get anything done on well, I mean, we'll see how the election turns out, but
Right.
at least as it stands, the chances that Congress is going to do anything that's pro-employee are pretty slim,
Mm-hmm.
and it's really a shame. I'm glad you're raising the issue, but I don't know anybody who is talking about the racial pay gap. There are a lot of people that are talking about the pay gap based on sex, and there are any number of pieces of legislation that have been proposed and interest to remedy that with a piece of federal legislation. But I'm not aware of it, except in as much, and this is not obviously dealing with race or sex discrimination per se, but
Mm-hmm.
raising raising the minimum wage to $15 an hour would certainly help a lot of people across the board. So there is that, and Hillary Clinton has supported that. Whether that has any chance in Congress, we'll see what happens with the next election. But the way it's been this past decade, there's just been no movement on any of these issues at the federal level. Now, on the state level, there have been a number of New York, California, New Jersey, I believe Connecticut, not on the issue of racial disparity, sadly, but on some other pro-employee pieces of legislation. Paid sick leave.
Yeah, California, I think, is another state that's
Yep.
really hitting that big time.
Yeah, paid sick leave, increasing the minimum wage. DC is looking at a number of very pro-employee pieces of legislation. Universal paid care. Raising the minimum wage. Legislation that would prevent retailers in particular from scheduling people at just random and hours that makes it difficult for people to control their own schedule.
Sure.
Particularly in retail. So there are those pieces of legislation at the state level, but there's not much. I'm not aware of anything that is addressing the pay gap based on race. So, Mark, maybe this is your calling. Start something.
Well, fortunately, there's some studies that are coming out, and one of I told you about before the show, Pay Scale is publishing one really, really soon. By the time this airs, I think they would have published it. And there's some that are similar with different salary tools and things like that. Glassdoor has published something recently where it's broken some ground.
Right.
So,
Yeah.
I think that is coming, and we're in a place right now where we should be talking about it more widely.
I think that's absolutely right, and it's to your point. I think it will be interesting to see. Getting a little far afield, but I do think it links up. What's going on with the Black Lives Matter movement. With the police violence, there is an awareness now, at least in some circles, that bias still exists, and implicit bias is beginning to get a lot more attention. And that may, depending on how that movement goes, that may eventually lead to more attention to things like the pay gap based on race. Right. So I think there's certainly hope for it.
Yeah, I think so as well. If someone's already working for a company where salaries are unfairly enacted, what can they do to prove the employer's responsibility along those lines?
Yeah, it's a sticky situation because in some states, in fact, in many states, it's perfectly legal for there's an argument that is legal for an employer to fire an employee for asking other workers, for instance, about pay. There have been a couple of states that have passed, there have been at least proposed legislation to make that unlawful, to make being fired for asking about coworkers' pay unlawful. And the National Labor Relations Board, which has typically been more active with unions, is playing a much more active role with private employers. And the National Labor Relations Board has taken the position that is perfectly lawful conduct. But so to answer your question, it's a little tricky.
Mm-hmm.
You run the risk if you make you publicly come out and start, or you come out and start asking employers or employ your coworkers, or you start agitating about this issue that you could get fired by your employer. So it depends on the state you're in and your tolerance for risk. Of course, there's always the age old way of just asking folks on the sly, kind of finding out what folks make.
Mm-hmm.
Um, in terms of again advocating with your employer about pay scale. It's a tough call again. Would you have, if you got fired, would you have a case that's illegal? Maybe, but you
Right.
do run the risk of getting fired if you're in a non-union environment uh, for raising those issues. So it's a tough call. And again, it depends on what sector you're in. If you're a high tech worker out in California, and you're well sought after, well, employers are going to do what they can to keep you, and will probably tolerate you asking those questions and advocating for yourself. If you're in a labor market where they can just as easily replace you with somebody else, well, that could get you fired. So
Right.
there's not an easy answer to that one.
Right. And I can see where maybe part of a large company, maybe part of their staff is unionized and part of they're not. So, I can see where if you're going to try to raise, when you do it on part of the union, they're looking at everybody, not just one individual. So it's kind of, I would think it would be kind of hard to compare those in the union, those who are not union, if they work in for the same company, that the salary conversation is going to be very much different.
Yes, that's exactly right. And with a union, you've got a lot more protection than you do in the private sector.
Yes, that's a very, and I think too, when people are going for, or a person of color who's looking at, doing a job search and they're getting ready to negotiate salary, I think some of them are probably thinking, well, how can I negotiate if I don't know anybody's salary, or whether I'm going to get a fair shot? And I think one of the ways, I mean, is as I'm troubleshooting it in my head, is that you go and you look at the company and see who are on the board. You see who's in management, and if there's nobody that looks like you, you might want to consider looking at different employers as opposed
That's right.
as
That's right.
opposed to if they are diverse and they're even fairly diverse, you would have a better shot, though there's not a guarantee, again, based on your research, but that should be a part of your research.
Sure, absolutely. And like you say, with Glassdoor and other places like that, other online resources, there are a lot more opportunities now to find what pay, what pay and salary is. But you raise a good point. You got to do your research, and if you're applying at a place that nobody there looks like you, that doesn't necessarily mean you shouldn't apply, but you might want to think about it. You might want to find out why that is.
Right, right. Well, Tom, I really appreciate this time, and this discussion has far exceeded my expectations. So, and
Well, good.
your law firm has a blog, even if people want to go to read for more information. You could tell us a little bit about that.
Yes, no, we put a lot of resources on our website, so you can go to www.spigglellaw.com, and that's
Mm-hmm.
S as in Sam, P as in Paul, IGGLE, law.com. And we have a number of different centers there, and we have a blog. So if you go to the website, you can find the blog there, and we publish pretty regularly on that.
Yes, and they do. I checked it out. It's fascinating. I think it's a must read, and definitely will include a link to the blog.
Right?
Tom, thank you so much for coming on the show. Um, um, hopefully maybe after the new year I might be able to get some more time with you so we can parse up some other discussions about discrimination, since that's I wouldn't say it's a main concern, but it's a concern in a lot of my audience that
Sure.
are trying to find opportunities but can't because of various reasons.
Yeah, no, absolutely. And just so I'll give you another possible topic, whether it's me or somebody else to look at, but there's a new big changes to the Fair Labor Standards Act, speaking of pay, that are going to be coming into effect on December 1st. So that's another thing for you and your listeners to be aware of. It's going to provide a lot more protections for workers, particularly those making under 40,000 a year. So just another
Awesome.
thing to leave you think about. But Mark, it was my pleasure. You do great work, and
Thank you.
I very much enjoyed this time together.
Thank you. And for the rest of you, thank you very much for joining me here on the Voice of Job Seekers. Please go to voiceofjobseekers.com, dig into the show notes. And if you have any questions, feel free to email me at mark@thevoiceofjobseekers.com. You can also call me or text me at 708-365-9822. We'll look forward to talking to you next week, which will be a great topic with payscale.com, having them back on the show. So look forward to that. I'll talk to you guys later.